Good morning, this is your Kelso Report for Thursday, February 9th. I'm your host, Clark Kelso. We begin with choice of law today. As a general matter, California follows a governmental interests analysis when considering choice of law questions. In the context of a choice of law clause in a contract, that analysis requires a consideration of whether the chosen state has some substantial relationship to the parties or transaction, whether applying the chosen state's law is contrary to a fundamental policy of California, and whether California has a materially greater interest than the chosen state in resolution of the issue. In Ruiz versus Affinity Logistics Corporation, the Federal District Court held that Georgia law applied pursuant to a contractual choice of law provision to resolve the issue of whether a worker was an independent contractor or an employee for purposes of determining compliance with labor laws regarding things like overtime pay, failure to pay wages for vacation, holidays, sick days, and severance, and payment for workers' comp insurance. The District Court chose Georgia law consistent with the contract and enforced the choice of law clause after concluding that Georgia had a substantial relationship to the transaction because the employer was headquartered in Georgia. But the District Court failed to undertake the second and third steps of the choice of law analysis. So the Ninth Circuit correctly held that California's worker protection laws reflect fundamental California policies and that California has a greater interest than Georgia in determining whether a worker who is employed in California and works solely in California is an independent contractor or an employee. Accordingly, the Ninth Circuit held that the choice of law clause was unenforceable, and the panel remanded for retrial in light of California law. The choice of law issue may be decisive because in Georgia the burden is on the worker to prove that he or she is an employee, while in California the general presumption is that a worker is an employee, and the employer has the burden of trying to establish the independent contractor relationship. Our next case involves the court's powers of contempt. The defendant in United States versus Kimsey was convicted of criminal contempt under 18 U.S.C. Section 402 for willfully disobeying a lawful rule of the district court. Now, Section 402 requires that the contempt proceedings be conducted in accordance with Section 3691. And Section 3691 permits the defendant to demand a jury trial. Nevertheless, the district court denied the defendant's demand for a jury trial, which the Ninth Circuit held was reversible error. The government argued that he was not entitled to a jury because the maximum punishment he could receive was less than 6 months' imprisonment. Well, true enough, that argument reflects the constitutional standard for jury trials, but Section 3691 clearly imposes a stricter requirement, and the violation of the defendant's statutory right to a jury trial was the basis for reversal. Our third case today involves a limitation of actions under the Federal Truth in Lending Act. Now, the Federal Truth in Lending Act is designed to ensure that consumers receive material information from lenders before entering into loan transactions subject to the terms of the Act. To ensure that lenders comply, the Act grants borrowers the right to rescind a home-secured loan in the event the lender has failed to make the required disclosures. But the Act contains a 3-year limitations period for rescission. In McCamey Gray versus Bank of America Home Loans, the Ninth Circuit held that the 3-year period operated as a statute of repose, and the clock began running on the date of consummation of the loan transaction, which was the statutory language. Although the plaintiff gave the bank notice of her intention to rescind within the 3-year period, did not actually file an action to rescind within the 3-year period. And the Ninth Circuit held her action was therefore barred. Our final Ninth Circuit case involves a constitutional issue. Ibrahim versus Department of Homeland Security. The ability of an alien who has left the United States voluntarily and been denied re-entry to sue federal officials for alleged violations of the First and Fifth Amendments was the issue before the Ninth Circuit and Ibrahim. Ibrahim had been a Stanford doctoral candidate from 2001 to 2005 here on a student visa. Near the end of her studies, she was invited to participate in a symposium at the University Putra Malaysia in Malaysia to present her research. Well, when she tried to board the plane for her trip, she discovered that she had been put on the government's no-fly list, and she was arrested and briefly detained. Now, ultimately, she was permitted to leave to attend the conference, but once in Malaysia, she was then not permitted to board a return flight to the United States, and she discovered that her visa had been revoked by the State Department. She sues to seek an injunction to have her name removed from any government no-fly list. And by a 2-to-1 vote, the Ninth Circuit held she had sufficiently voluntary connections to the United States to permit her to maintain her action. The dissenting judge disagreed and argued that she lacked any substantial voluntary connection to the United States, so she shouldn't have standing to sue for a constitutional violation, and that in any event, the alleged harm is ultimately non-redressable. The case now goes back to the district court for further proceedings on the merits. And she may discover that it is, in fact, non-redressable, because it's clear that the State Department's decision not to grant a visa is not judicially cognizable, reviewable. Well, we turn now to California Court of Appeals. We have 2 tort decisions. The plaintiff in the first was taking a shower at a hotel when he slipped and fell in the bathtub. A lawsuit against the hotel and manufacturer followed. The complaint alleged the tub was defective because its coating did not comply with applicable standards, and the hotel was sued on a theory of premises liability and negligence. The trial court granted the defendants separate motions for summary judgment, although it then granted a new trial as to the hotel. Well, in Howard v. Omni Hotels Management, the 4th District held that the plaintiff failed to meet its burden of proof to dispute the evidence brought forward on the motions for summary judgment. The manufacturer produced the applicable industry manufacturing standards and showed that the tub, in fact, complied. The hotel relied on this showing in contending that it did nothing unreasonable in its management of its property. The plaintiff lost this case when his own expert concluded that the bathtub did comply with the minimal industry standards for coefficient of friction and surface area coverage. Nevertheless, in the expert's view, he argued the tub was still dangerously slippery. Well, not surprisingly, the trial court in 4th District seized upon the concession that the tub complied with applicable standards. That pretty well ended the case, since the expert's personal conclusion that the tub was too slippery does not establish a different standard of care or a fact question for a jury. Another slip and fall case. Now, when it comes to premises liability cases, the general rule has been that a dangerous condition on business premises that are not open to the public may be the basis for liability only if the business has actual or constructive notice of the dangerous condition. But in Getchell v. Rogers Jewelry, the 3rd District held that this rule did not apply, since the evidence produced by the plaintiff in response to a motion for summary judgment was sufficient to suggest that the jewelry cleaner solution on the floor of a back room at the store had been spilled as a result of the negligence of one of the store's employees. According to the court, when the dangerous condition was created by the negligence of an employee over whom the defendant had control, the actual or constructive notice requirement does not apply, and liability can attach simply as a matter of vicarious liability. Well, that's it for today's Kelso Report. I hope you all have a safe day without slips and falls, and have a great day in the law.